where that could profitably enlighten and benefit us. The concern is rather to safeguard against the possibility of being blinded by it. pp. 4.5-487. 36 Supreme Kult Repgerts, 1973. Supasielden and Re the Control Provinces and Berar Act No. 5 of 1938, 1939 FCR, 18. Special Reference I of 1964, 1965. ISCR 413 at 487 referred to. The facts that the preamble professed in unambiguous terms that it on the people of India who have adopted, enacted, and given to themselves their constitution, that the constitution is being acted upon unquestioned for the last over 23 years, and every power and authority is purported to be exercised under the constitution, and that the vast majority of the people have, acting under the constitution, elected their representatives to Parliament and the state legislatures in 5 general elections, make the proposition indisputable that the source and the binding force of the Constitution is the sovereign will of the people of India. Throws this assumption. No state need have unlimited power, and indeed in federal politics no such doctrine sustainable. p. 494. The amending power is a facet of the constituent power but not the whole of it. The power under Article 368 after the amendment, still described as amending power. The 24th Amendment makes this explicit because it did not want a doubt to linger that because the same body, namely Parliament, makes both the ordinary law in terms of the grant in Article 245 to 348 and CL an amendment in terms of Article 368, it should not be considered that both these are legislative law within the meaning of Art 13.2. On the view taken that Article 13.2 is confined only to the ordinal legislative laws and not one made under Article 368, the addition of Clause 4.1 to Article 368 insofar as it declares that when Parliament exercises the power, UN 4CR that provision, it exercises its cis institucent power and makes implicit what was implicit. The amendment therefore makes no change in the position which prevailed before the amendment. It is not DCCC's. To consider the Q11 question of the existence or non-exist CNCC of implied or inherent limitations, BCC LSC, if the amending power is wide and plenary, those limitations can be OVC1ITDCN, as indeed the non-ob slant. Clause in the amended clause, I of Article 368 was intended to subserve that 1D. What as ID be considered is whether the word tamendment is wide enough to confer a plenitude of power, including the power to repeal or abrogate. The outstanding question, then, is, what is meaning of the word amendment? Whether it has wide or restricted meaning, whether it includes repeal or revision, and whether having regard to the other provisions of the Constitution or the CID, on text of the word amendment in Article 368 itself, it has a restricted meaning, so as not to refer a power to damage or destroy the essential features of the Constitution. If the word amendment has a restricted meaning, has that power been elarged by the use of the word amend by way of addition, variation, or repeal? Or do DTSI mean the same amendment? If they arc wider than amendment, could Parliament in CX ratio of its amending power in Article 368 enlarge that power when pi? 495, 496. It is necessary ID ascertain from the background of our national aspirations, the objectives adopted by the Constituent Assembly, as translated into a whirling organic instrument which established a sovereign democratic republic with a parliamentary system of government, work under individual rights of citizens, the duties one towards the community which the state will enjoined, to discharge the diffusion of legislative power between Parliament and state legislatures, and the provision for its amendment, etc. are provided all TI. Aspects were sought to be well balanced as in a ship built for fair weather as well as for foul. Thithen Willix, the proper approach. The recognition of the TRW SIA that power corrupts and AOOLICH power corrupts, absolutely has been the WT. Damn that made practical men of Sikap Kriknoe and not only drawing up a written constitution, limiting power of the legislative's organs Hutton Siunt to all citizens. LT Kesavananda. TI Kerala 37 certain basic rights against the state. If the faith in the rulers is so great, and the faith in the people to curb excessive exercise of power or abuse of it is potent, then one needs no elaborate constitution. because 11 all that is required is to make Parliament omnipotent and omni-sovereign. This the framers did not do, and hence the question will be wagier by an amendment under Art. 368 Parliament can effect a metamorphosis of power by making itself the supreme sovereign. It is against abuse of power that a constitutional structure of power relationship with checks and balances is devised, and safeguards provided for whether expressly or by necessary implication. The question is whether there are any such in our Constitution.